Good morning and welcome to the Maryland Public Service Commission's administrative meeting for August 19th, 2020. We have 8 items on today's docket. Before we turn to the business component of the meeting, we have minutes to approve from last week's meeting of August 12th, 2020. The vote begins with Commissioner Richard.
I was absent last week, so I pass.
Commissioner O'Donnell.
Mr. Chairman, I was also absent last week and will pass.
Commissioner Linton.
Aye.
Commissioner Herman.
Aye.
I too vote aye. The meeting minutes are approved. Good morning, Mr. Secretary.
Good morning, Mr. Chairman. There are 3 items on today's consent agenda. Item number 1 is a notice of debt financing from FiberLight LLC. Item number 2 is a notice of participation in a financing agreement from Level 3 Communications LLC. And item number 3 is a designation of weather stations from Shop Tank Electric Cooperative, Inc.
Thank you. Seeing no questions from the commissioners, I move that with respect to item number 1, we note the financing. With respect to item number 2, that we note the financing transaction. And with respect to item number 3, that we approve the weather station designation for the purpose of determining when there is an extreme weather period under COMAR Title 20, Subtitle 31, Chapter 3, Regulations 3 and 4, which impose a restriction on termination of a service due to a customer's non-payment. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I also vote aye. The motions are approved. Mr. Secretary.
Mr. Chairman, item number 4 on today's administrative agenda, which was deferred from the August 5, 2020 administrative meeting, consists of Smartest Energy US LLC's application for a license to supply electricity or electric supply services. For this item, we have for staff Nan Zhang and Kenneth Albert, for the company Jim Sefarada, Andy Cormie, and Kayla Austin, and for Office of People's Counsel, Patrick O'Loughlin.
Thank you. We'll begin by hearing from Commission staff.
Good morning, Chairman, Commissioners. Nan Zhang on behalf of staff. On February 13th, 2020, Smartest Energy US LLC filed an application for a license to supply electricity or electric generation services in Maryland. Additional comment was filed on August 13, 2020, regarding OPC's concerns about the potential for customers to be confused or misled by the similarity between the company's name and the BGE Smart Energy Program. The company agrees to place and maintain on its website a statement affirming that it is not associated with or affiliated with BGE or BGE's Smart Energy Program. In the event that the company begins any marketing programs to residential customers, it will include on all residential marketing materials a statement affirming that it is not associated with or affiliated with BGE or BGE's Smart Energy Program. Staff recommends that the Commission grant the company a license to operate as an electricity supplier in Maryland. Staff also recommends that the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Thank you for that recommendation, Ms. Zhang. We'll now turn to the representative from the Maryland Office of People's Counsel. Do we have a representative from OPC?
I apologize, Your Honor. I was muted on my phone, even though I thought I had unmuted myself. My apologies. Patrick O'Loughlin, Maryland Office of People's Counsel. We, at your direction, had a good conversation with the company wherein we reached an agreement on the set of conditions that staff has just noted and was also noted in a separate filing from the company. And with that, we feel comfortable and do not oppose granting of this license.
Thank you, Mr. O'Loughlin. Finally, we'll turn to the company, Smartest Energy US LLC. We recognize that the company filed supplemental comments on August 7, 2020. If the company can please make an appearance.
Thank you, Chairman Sonic. My name is Andy Cormie. I'm CEO of Smartest Energy US LLC.
First, let me apologise unreservedly for not being available for the previous call. We had no intention of delaying this discussion, so our sincere apologies for that. We recognise some of the conversation that was had last time and appreciate the challenge that the Commission brought in respect to some of the issues that Marubeni have faced in the past, our parent company. Like the PSC, we see these as very critical and important issues which should absolutely be confronted. Marubeni has put significant effort into addressing the corruption and compliance issues of the past with advancements in corporate governance, around training and support for staff, also around implementation of control mechanisms throughout its supply chain. These are controls that we benefit from, but I'm quite keen to emphasize that the application is actually on behalf of Smartest Energy. We have 20 years experience of exemplary standards across the globe, and we try and bring them to the US as a recognized leader in our field with the best customer service for C&I customers across the UK for something like the last 10, 12 years, having won Supplier of the Year twice in the last 10, including just last year as well. The heart and mind of our business is with our board, and we fund and operate our business on the basis of partnerships, directly working with brokers only, not providing direct sales to customers. Those relationships are critical to us, and if we cannot maintain them and support them in the right way, then we cannot succeed. I hope the Commission can see that the support that we've got from our parent and the way in which we operate here and globally with our American team is sufficient to approve our licence. We're also happy to make whatever recommendations are required by the Commission, and also, I think, have followed all the guidance required so far. Happy to take any detailed questions.
Thank you, Mr. Cormie. Do commissioners have questions of Mr. Cormie or the parties in this case? Seeing none, I am pleased with the fact that Office of People's Counsel and the company were able to reach a resolution that was memorialized in the correspondence by Smartest Energy LLC US. I will condition the motion based on acceptance of that commitment as follows. I move that we grant the company a license to operate as an electricity supplier in Maryland for the customer classes and service territories applied for and recommended by staff, subject to its commitments in its letter dated August 7, 2020. And that we direct the company to file notice with the Commission within 30 days of any changes to the information in its application. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
Commissioner Herman.
Aye.
I also vote aye. The motion is approved.
Mr. Chairman, item number 5 is the notice of internal reorganization and request for concurrence from GenOn Mid-Atlantic LLC. On this item, for staff, we have Michael Dean and Kevin Zong. For the state, Bill Paul, Steve Tulson, Michael Strand, and for the company, David Kramer and David Franchina.
Thank you. We'll begin with a presentation by Commission staff.
Commissioners, Michael Dean on behalf of staff. Item 5 is a filing by GenOn Mid-Atlantic LLC giving notice of an internal reorganization in which its gas and diesel powered generators at its Chalk Point generating stations will be transferred to 3 new separate entities. The filing also requests on behalf of Maryland Department of the Environment to issue new and modified permits and minor administrative changes to the conditions for certificates of public convenience and necessity, or CPCNs, associated with the. There is no statutory requirement to obtain pre-approval of the sale or transfer of a generating station. Public Utilities Section 708 F and G provide that the Commission shall include in each CPCN the conditions that implement the federal and state environmental conditions recommended by the Department of the Environment. For these reasons, the Commission should note the reorganization of its generating units in Maryland and the issuance of new and modified permits by reorganization as described in the filing. Any minor administrative changes to CPCN conditions required by the reorganization shall be filed with the commission. Thank you.
Thank you, Mr. Dean. Do any Maryland state agencies wish to make an appearance or provide testimony? Hearing none, we will turn to representatives from Genon.
Yeah. Good morning. My name is David Kramer with Genon. We are available for questions. We don't actually have anything to offer other than what we submitted to the commission previously. Thank you.
Thank you, Mr. Kramer. So you agree with staff's recitation?
Yes, we do.
Thank you. Do commissioners have questions? Seeing none, I will move that we note the reorganization of the company's generating unit in Maryland and the issuance of new and modified permits by Maryland's Department of Environment as necessary in connection with the reorganization as described in the filing, and direct the company to file with the commission any minor administrative changes to CPCN conditions required by the reorganization. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I also vote aye. The motion is.
Mr. Chairman, item number 6 consists of revised tariff pages from Maryland American Water Company proposing to introduce a Bel Air impoundment property tax rider. This item for staff is Peter Wilson, Elvia Kuykendall, Afton Howard, Felix Patterson. For the company, Gary Akmentis, Mr. Chairman Frisbee, and Christine Soares, and for the Office of People's Counsel, Anna Ryan.
Thank you. We'll begin with Commissioner.
Good morning, Chairman and Commissioners. Peter Wilson on behalf of staff. Maryland American Water Company's last rate case, number 9487, coincided with the completion of its new Bel Air impoundment facility in January of 2019. The filing under consideration today requests approval of a proposed property tax rider and revised tariff made in compliance with the Commission's order number 89022 dated February 5, 2019, which approved the parties' settlement and proposed order in case 9487. The tax rider will allow the company to recover property taxes associated with the impoundment facility, which could not be included in the last rate case. Property taxes will be assessed on the property as of July 1 of this year, which is the start of the current tax year. But the actual assessment will not be received until September or perhaps October of this year. Consequently, staff has calculated its proposed monthly surcharge based on the most recent property rate for the current tax year to be billed over the 10 months remaining in the tax assessment period. The company will conduct and file for approval a true-up, to adjust the surcharge once the actual assessment is received. Thereafter, the company will file yearly until its next rate case. Accordingly, staff recommends that the Commission direct the company to revise the tariff as proposed by staff and file clean copies with an effective date of August 19th, 2020.
Thank you, Mr. Wilson and the staff team. We'll now turn to the Maryland Office of People's Counsel.
Good morning, Your Honor. Office of People's Counsel would just like to support staff's modification recommendation. The PTR was originally implemented, it's designed to bring the ratepayer impact of the increase in property tax assessments in line with the time when the company incurs those costs. And we believe that the staff's proposed modification is a step bringing that closer to, related the rate impact to the cost. So we would support that as well. Thank you.
Thank you, Ms. Ryan. We'll now turn to representatives or counsel from the company. Chairman Frisbee, you may be having difficulty unmuting at this time. Or do we have another representative from Maryland American Water?
Hi, Mr. Chairman, may I speak? This is Gary Ekmenton.
Yes, you may.
I'm the Senior Rate Manager for Maryland American Water, and we do not object to staff's proposed proposal nor OPC's concurrence.
Thank you. Do commissioners have questions of the parties with regard to item number 6? Seeing none, I will move that.
I'm sorry, Mr. Chairman. I just wanted to say good morning, Chairman. I don't know if he's still on, but if not, I haven't seen him in a while, so I'm glad to see he's doing well.
I think I'm on now. Sorry.
Chairman Frisbee, I think we could hear you.
Problem.
There we go. Chairman Frisbee, you're with us now.
Okay. Just wanted to say that I support that entering my appearance, apologize for the technical problems, and as Mr. Ekmenton said, Maryland American Water supports the staff proposal.
Thank you. You may have missed a greeting from Commissioner Linton a moment ago, but it's always good to see you.
Thank you very much. It's good to be seen.
At this point, I will move that we direct the company to revise the tariff as proposed by staff in its comments dated August 11, 2020, and direct the company to file clean copies of the revised tariff with an effective date of August 19th, 2020. The vote on the motion begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell. Commissioner O'Donnell, your vote wasn't logged.
I'm sorry, aye.
Thank you. Commissioner Linden.
Aye.
And Commissioner Herman.
Aye.
I also vote aye. The motion is approved.
Mr. Chairman, item number 7 is an application from Artesian Water Maryland, Inc. for approval to exercise a franchise provided by Cecil County. On this item, we have Catherine Mackerlane for staff, and for the company, Scott Stephen, David Spacht, and Joe D'Annunzio.
Thank you. We'll begin with the presentation by Commission staff.
Good morning, Chairman and Commissioners. Catherine Mackerlane on behalf of staff. Artesian Water Maryland, Inc. is requesting authority to exercise an extension of its port deposit franchise that is described in the First Amendment to the franchise agreement granted by Cecil County on June 19, 2020. The port deposit franchise reflects an original franchise area and an expanded area by virtue of the First Amendment to the franchise agreement. The First Amendment to the franchise agreement expands Artesian Water's port deposit franchise to include all property in Cecil County. The Commission authorized Artesian Water to exercise the port deposit franchise by order number 83513 in case number 9237 on August 3rd, 2010. In this order, the Commission found that the company had the managerial and financial means to operate and maintain a water system in Cecil County. Artesian Water filed copies of the franchise agreements, articles of incorporation, affidavits of its directors, and maps of the franchise area in accordance with the Public Utility Companies article and the Code of Maryland regulations. Staff recommends that the Commission grant authority for Artesian Water Maryland, Inc. to exercise the franchise provided by Cecil County as described in the application. Thank you.
Thank you, Ms. Mackerlane. We'll now hear from our representative from Artesian Water. There we go. If you could start over, we missed the first part.
Good morning. This is Dave Spacht. I'm the CFO and treasurer of Artesian Water Company, Maryland. And we've read through staff's comments, agree with the comments, and look for your approval of the order to service or exercise our right to serve this additional territory connected to port deposit. Thank you for hearing us this morning.
Thank you. Do commissioners have questions of the staff or Artesian? Hearing none, I would move that we authorize Artesian Water Maryland Incorporated to exercise the franchise provided by Cecil County as described in the application. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Oh, aye.
And Commissioner Herman.
Aye.
Also vote aye. The motion is approved.
Mr. Chairman, item number 8, which was also deferred from the August 5, 2020 administrative meeting, consists of revised pages from Southern Maryland Electric Cooperative, Inc., reflecting a proposed new rider, SOSG Standard Offer Service Green. On this item for staff, we have Lloyd Spivak, Michael Dean, and Kevin Mosier. For the company, Mark McDougall and Eugene Bradford. For Office of People's Counsel, Jacob Oslander. For the Retail Energy Supply Association, Brian Green. And for the Sierra Club of Southern Maryland, Benjamin Hance.
Thank you. Good morning and welcome back to all the parties and litigants in this proceeding. When we last left off 2 weeks ago, I informed the parties that they may but were not required to file additional pleadings or supplemental filings. RISA did take advantage of that, making a filing on August 17th of 2020. I will provide the parties with an opportunity to elaborate on any additional comments or concerns. And then we will allow the commissioners to ask any follow-up questions that they may have considered in the interim period over the past 2 weeks. I'll begin in ordinary course and allow staff to provide any update or statements if they wish.
Good morning, Mr. Chairman. It's Lloyd Spivak for the commission staff. With me are also Michael Dean and Kevin Mosier. We really do not have much to add to our previous statements on this item. Our position has not changed. However, I would like to respond to just one point that was in RISA's letter. They make the statement that SMECO seeks to offer a product that competes with products offered by other retail electric suppliers within its distribution territory without complying with the same licensing and consumer protections applicable to those suppliers. We find that statement just a little bit misleading. We note that SMECO is fully regulated by the Commission and has to comply with regulatory standards and oversight that are more comprehensive and at least as rigorous as those imposed on suppliers. One point that I'm not sure came out clearly at the last session, which needs to be emphasized, is that a REC purchased through a supplier has exactly the same effect on the fuel mix used to supply electricity in SMECO's service territory as one purchased by SMECO. If Mr. Smith uses 1,000 kilowatt hours per month and wants 100% of that to be offset with solar RECs, the effect of purchasing those RECs through a supplier is exactly the same as if they were purchased through SMECO. And with that, staff is available for questions, and we'll leave further comments to the other parties.
Thank you. Turn to Office of People if you have any additional comments.
Thank you, Mr. Chairman. Jacob Auslander on behalf of the Maryland Office of People's Counsel. I actually don't have anything more to add either. The position that we've taken previously is still OPC's position. We recognize that there might be a burden on retail suppliers that are operating in SMECO's service territory that are offering similar products. But the choice that a customer would make to choose SMECO's product with the green, the additional green content, could be based on that customer's review of the offers that are provided by competing suppliers, and the way these deals work, as many consumer products, you take it or leave it. So if there's a green product that has certain conditions that if the customer does not seek to take on, that then they might forego the opportunity to purchase the green product. So we support SMECO's request, and we would recommend that the commission approve the revised tariff provisions.
Thank you. We'll next turn to representative from the Sierra Club.
Thank you, Mr. Chairman. Can you hear me clearly? Good morning. My name is Ben Hance from the Southern Maryland Sierra Club. I'm speaking today on behalf of the 5,000 members and supporters of the Southern Maryland Sierra Club within SMECO's distribution area. I will note that we didn't submit any additional written comments. We felt our original comments were full and in the right and needed no supplement. I would like to take a moment to address RISA's supplemental comments, though. And while I take no issue with the lawyers for RISA interpreting COMAR and the laws in a manner that benefits their clients, I would point out that the Office of People's Counsel, whose name is self-explanatory, has supported passing the rider. There are a few issues with RISA's comments that I will take a moment to address. First of all, I'd like to start out with reminding everybody that it's pronounced SMECO, not SMECO. There was a little issue with that last time around. First, I would like to address the fact that, in our opinion, the comments from RISA conflate customers with member owners. It refers to people of Southern Maryland several times as the customers of SMECO. We are not customers as a co-op. We are member owners of SMECO. I feel that is an important thing to address, especially when addressing the idea of demand and what member owners can demand of a cooperative, which is treated differently than an investor-owned business. Again, I would like to address the fact that RISA brought up that perhaps SMECO should do more education of its member owners with the customer choice. I addressed this last time, that assuming that the people of Southern Maryland are ignorant of the choice, or as previously brought up, easily confused, I feel is unfair to the population of Southern Maryland, and I feel is a poor tactic to take when arguing their case. I would also like to bring up the fact that even though I addressed the claim of over a dozen choices for clean energy under the customer choice option, that remained in their supplemental comments. As I addressed last time, several of those choices are exactly the same choice. Several are only 5% wind powered and thus not really renewable at all under SMECO's current renewable portfolio. And yet that dishonest claim remained, which implies either a neglect of the arguments made last time or just an attempt to perpetuate that dishonest claim. Other than the slippery slope.
I'm going to step in at this point. You can't cast aspersions or what the intent of counsel for RISA was attempting to say, but this is your opportunity to respond with your comments to any issues that you saw in RISA's most recent filing.
Okay, my response is that 12 options claim was wrong before and is still incorrect now based on their categorization of it as renewable options. That ends my commentary on RISA supplemental comments. However, I didn't get to speak towards the end of the last meeting, and I would like to state that, once again, the idea that exceeding the mandates of the Clean Energy and Jobs Act should not be viewed as a burden. It should be viewed as prudent and in the public interest, because the Clean Energy and Jobs Act is itself moving towards clean energy in order to combat the climate crisis, which is inherently in the public interest. Additionally, it was noted last time that there is no prohibition explicitly stated on a green SOS. And if there's no prohibition, then there's no prohibition. The implied prohibitions, I feel, goes against, well, frankly, American values at a constitutional level. The idea of the 10th Amendment, any powers not given to the federal government are relegated to the states and then to the people. If we are not limited, then we are free to make the choice. Once again, on behalf of the 5,000 members of the Southern Maryland Sierra Club, I would like to thank you for the chance to speak.
Thank you. At this time, we will turn to counsel for RISA to respond to any of those comments or elaborate on your filing.
Good morning, Mr. Chairman, Commissioners. Brian Green for RISA. Just a couple of quick responses. So much of the discussion from August 15th was on statutory interpretation of 7-510C8i that we thought it would be helpful to the discussion to do some research on the canons of statutory construction and how those canons apply to not just the wording of 710C8 specifically, but also the canon that you have to interpret a statute of words in a statute consistent with the overall statutory scheme. So that's important because the term demand, as used in all throughout 7-510, is an energy specific term. It's used at least two other places in 7-510, in C4 and C6, and it means what it says. In the energy context, it does not mean, as SMECO advocated 2 weeks ago, that it's basically anything that its customers may want, that it can approach SMECO and SMECO's board can make the determination as to whether to provide that product or service. That is not what the specific wording says and means. It's not how it should be interpreted, nor is it consistent with statutory structure or scheme as a whole, which is to promote retail choice. The 7-510 or the Energy Choice Act as a whole provides specific responsibilities for utilities. It deregulates generation, supply, and pricing, and mandates that the utility engage in distribution services, ensure reliable service, and provide SOS. And SOS is also a defined term. So here we have SMECO proposing to step out of that role and provide a value-added service or an alternative SOS, whatever we want to call it, because it was called both at the August 5th meeting, neither of which is allowed for in the statute. So if you look at 710C8I, what it says is that they were providing SOS through a blended portfolio before 2006, they can continue to do so to meet demand in a cost-effective manner. What SMECO is proposing is not to meet demand. It's an extra value product that customers can pay for. So that's the premise of the comments that we filed, and just and I'm happy to answer any questions about the case law and what we stated, but let me just respond very quickly to staff and Sierra Club's comments. So with respect to the distinction that we're making with respect to the consumer protection rules that apply to suppliers and the licensing requirements is very different. When you dig down into the weeds, very different from what the utilities go through. So granted, no one can engage in misleading comments, no one can do things improper, and certainly utilities are regulated. So Mr. Spivak is 100% correct on all of that. My point was that there are specific COMARs, and suppliers are by definition different from utilities. So there are specific consumer protection COMARs. When we sign up a customer, a supplier must do specific things in the COMARs that are set out, depending on the marketing channel and so forth, and we have to adhere to that, or else our license can be in trouble, or we can incur penalties and fines. That's the point I was trying to make. It was certainly nothing misleading about that. And then second, with respect to what's on the website right now, the website says what it says. It's a commission website. The commission can certainly take judicial notice of that. I looked at it right now, and there's 12 products being offered if you filter it by renewable in the SMECO territory. One of them may be duplicative. So whatever it says, if it's 11, if it's 12, the point is that there are offers available on the website that suppliers are offering right now today, renewable products in the SMECO territory. And yet here's SMECO trying to jump out of its role as a utility and compete with those value-added products, which we do not think is allowed for in the statute, nor do we think that the commission has the discretionary authority to allow it. So I'll stop with that, and I'm happy to answer any questions that the commission may have.
Thank you, Mr. Green. Before we get to commissioner questions, we'll allow the cooperative to provide any comments or responses.
Thank you, Mr. Chairman. Good morning. I'm Mark McDougall on behalf of SMECO. With me today also is Eugene Bradford, and we'll after I take a moment to address RISA's supplemental comments that will be available for questions. We addressed most, if not all, of the issues raised by RISA 2 weeks ago, but I'd like to take a moment to respond again to them today. The first is on the reference to the word demand in section 7510C8 little I. Certainly, as Mr. Green states, demand can mean kilowatt hour demand. That is one of the natural and ordinary meanings of that word. Another natural and ordinary meaning of that word is the state of being sought after. Webster's defines it that way, such as renewable energy is in great demand. So I submit that there are at least two natural and ordinary meanings of that word. But nothing in the Public Utilities article suggests that the limited definition that Mr. Green suggests that the commission ought to take be used here. I'd like to focus on the entirety of that section, however, because Mr. Green said we should interpret the overall statutory scheme. So if you look at the entirety of section 510C8 little I, this section allows the co-op to supply standard offer service through a blended portfolio of wholesale supply contracts and other appropriate electricity products and strategies as approved by its board of directors. SMECO's board of directors has approved Rider SOSG to meet the desire or demand of its members for the company that they own. That was to Mr. Hance's point. Our members own the company to provide a green option. And since SMECO only uses standard offer service to provide electricity to its members, a rider to its SOS seemed to be the best way to accomplish meeting that demand. Also in Reese's comments, Mr. Green stated that nowhere did the General Assembly provide for any electric company, including electric cooperatives, to offer REC products beyond SOS, the electricity supply, and that they are not needed to serve customers' SOS demand. Well, Rider SOSG is not beyond SOS. It is SOS with a green alternative. The code does not mandate the components of standard offer service, but it gives SMECO's board of directors broad authority to approve the portfolio that cooperative offers. RISA also says that standard offer service was always intended to be a vanilla product for all utilities, a standard backstop service. Well, of course, it is a backstop, but it's not just a backstop. If one were to look at section 7510C2 little v, the code says that standard offer service is available to somebody who chooses standard offer service. That's not a backstop, it's a choice. So standard offer service goes beyond this plain vanilla backstop that Mr. Green insists that it is and always was. Mr. Green also mentions, he says that the commission doesn't have the discretionary authority to to approve SMECO's use of a blended portfolio in a manner not authorized by the Public Utilities article. Well, he says the Commission's powers are limited to those specifically conferred by law and cannot exceed the scope of the statute it seeks to implement or enforce. Well, I agree with that. But SMECO's position is that it's asking the Commission to approve something that is entirely consistent with the powers that have been conferred upon it by law. The next point that RISA has is that they claim that providing objective information about rider SOSG would violate the affiliate regulations. We talked about SMECO being able to provide unbiased information about the availability and terms of standard offer service under the affiliate regulations. RISA has argued that because rider SOSG is not a plain vanilla product, no information about it could be unbiased. It's simply impossible. Well, nothing in the Public Utilities article says or even suggests that SOS must be a plain vanilla product. So whatever SMECO's standard offer service is comprised of, COMAR allows the cooperative to provide information about its availability and terms. And finally, RISA says that approving rider SOSG would, I guess for the most part, open Pandora's box and allow other utilities to file for similar riders. The Public Utilities article in many places treats cooperatives and investor-owned utilities differently. And this may very well be just one of those instances. A commission order approving this rider can be as limited or as broad as the commission wishes. If it wants to make it specifically apply to SMECO or more broadly to apply to all the utilities in Maryland or somewhere in between, it can certainly do that. And they're my comments, and we are available for any questions you might have.
Thank you, Mr. McDougall. As RISA points out, a statutory provision should be read in context and harmonized with other related statutes and the overarching statutory scheme that was put in place back in 1999. I appreciate RISA's brief. It put things in perspective for me. With respect to the term demand, I believe RISA is absolutely right in its construction of the word demand. I don't view it as a customer preference. I do view it as an electricity demand. Even in the light most favorable to SMECO, I could not contort the definition to satisfy the position that would best favor the utility in this case. That said, I think the linchpin here of this decision rests on 7510 C8.1. And looking back to this, and Mr. Green, I'm going to have a question for you in a second. And I know we've all spent a lot of time looking at this provision lately, and I'm going to paraphrase, but it states an electric cooperative that as of July 1st, 2006, may choose to continue to use a blended portfolio. And that is only subject to two limitations: approval of the board of directors of the cooperative and subject to the appropriate review of this commission for prudent review of cost recovery. Obviously, co-ops are treated vastly different than investor-owned utilities or other utilities in the Public Utilities article. They do not have any obligation to provide a default service, the SOS service. And the wording of that statute, even read and harmonized with other statutes, appear to give cooperatives additional flexibility that would allow them to, dare I say, offer SOS default products that are something different than vanilla. So, Mr. Green, I recognize that utilities do have an inherent advantage in this marketplace to offer up a service and have an advantage when competing directly head-on with your member companies. But it appears when you look directly at that one provision, it's clear that there is some flexibility, at least in this commissioner's mind, to to offer additional products and services. And in fact, the language quotes, they may offer a quote appropriate electricity products and strategies as needed to meet demand in a cost-effective manner, not in a least cost manner, but a cost-effective manner. And on that score, I think SMECO has made a rather persuasive argument. So I'd like to hear your response, Mr. Green.
Sure. So I think they've got the order of the words misplaced. They've got them out of order. The statute is that if they use the blended portfolio or other appropriate electric products and strategies as needed to meet demand, they can continue to do so. So it's all, whatever blended portfolio plus other products they use has to be constructed to meet demand. And what we have here is a proposal that it has nothing to do with the customer's demand. It has to do with a rec product that's above and beyond what their demand is. So our position is that if you read it as SMECO does, or SMECO, excuse me, does, that that it's a blended portfolio as needed to meet demand plus other products and services, that's one thing. That would be an entirely different result. But it's a blended portfolio and other products as needed to meet demand. So we're still capped at the level of demand that is needed to provide SOS. Anything above and beyond that is in excess. It's a value-added product, or it's a different SOS altogether. This is not just one SOS product. So I respectfully disagree with SMECO's position that that just because the board approves it, it's okay.
Mr. Green, is the actual supply or sale of electricity changing in your perspective under Rider G?
The actual SOS product that the customer gets, no. It's just this add-on rec product that gets them from the RPS level up to 100% renewable, if that answers your question.
Thank you. Well, this section, I would concede, is not a model of clarity. There are a number of clauses, half dozen commas, attempting to modify other provisions here. I can see a very strong argument that the blended portfolio needed to meet demand can contain these additional electricity products. It's the legislature was not necessarily clear on this point. It's left it to this commission to make this statutory interpretation based on not only Sub 510C, but the 99 Choice Act as well. As I stated earlier, SMECO in this instance is not including any markup or profit here in terms of offering this product to customers. In that sense, if a owner member of the cooperative chooses to select the Rider G, if approved, that appears to continue to be a cost-effective product. I may have additional questions for the parties. Let me turn to my colleagues to see if they have questions of any of the parties before us today. And please speak up. I can't see all the commissioners on my screen today, so feel free to jump in.
Mr. Chairman, I have a couple questions.
Good morning, Commissioner O'Donnell.
Thank you. So, Mr. McDougall, I wanted to ask you about our website and if this product is approved, how it may be displayed as the kind of the basis for the retail supplier portion of our website, Shopping for Electricity in Maryland. Will you have two products there or one product? What will you be displaying on our website, and how often will you update it, if you would?
Right now, our website displays standard offer service, and it's updated monthly for the price that that SMECO offers for its standard offer service. I believe, well, we haven't designed anything now, but I believe what we would do is simply have an additional line or piece of information on that part of the website that said for customers who desire a green option, Rider SOSG is available at a particular price.
Yeah, I think you're answering my question about your website. I'm asking about the Public Service Commission's website on customer shopping in the state of Maryland for electricity.
I'm sorry, Commissioner O'Donnell, I didn't understand. And maybe I don't know exactly how the commission's website works. Do the companies update that, send in information to the commission about how that's updated, or?
Yes.
Okay. Well, I guess similar to the way I would envision SMECO's website to work, SMECO would send into the commission its standard offer service price as it's displayed today, but also note that a rider SOSG is available at an additional cost. And as frequently as it's updated today, which I believe is monthly, it would be updated monthly as well.
Okay, thank you. And so if SMECO and its board of directors, for us as member owners, because I'm a member owner too, to be honest with you, not the only one in the room, wanted to approve another product based on popular demand, which, by the way, I think to advocate that word in the statute, demand, that's being debated and bandied about could mean popular demand, I believe, in my mind, I'm sorry, but it would be a ridiculous interpretation when you consider the construct of the statute. That's just my opinion. I happened to be in the legislature when that piece of legislation passed, and it didn't mean popular demand. I can almost guarantee you that. It meant electric demand, and I think everybody ought to concede that and quit arguing that it could mean popular demand. But if SMECO wanted to offer another product, and this board of directors approved it, maybe the bundling of electric vehicle charging rider with green rider for Rex and SOS as a third option, if we approve this, could they do that?
Commissioner O'Donnell, I hesitate to even go that far because I view this filing as specific to this particular issue. The company and the board have not considered any other components to its standard offer service. We've heard nothing from its members about other types of bundled products, whether that be nuclear or wind or what have you. So I've always viewed the commission's approval, if we were able to get it, on this rider SOSG as specific to this particular rider. We would have to look long and hard before we offered some other products because, just as we did this, but those sorts of, I'm going to call it demand, that demand from our members hasn't risen. So I think we're only looking at this right now, Commissioner.
Yeah, but again, we're getting back to demand in my mind in the statutory construct, electricity demand. And if you keep going back to that,
maybe I should use a different word. Desire is maybe the word I should have used rather than demand.
Fair enough. Fair enough. So the argument that I hear that there's no statutory prohibition on you offering this, why wouldn't that apply to other products or other services or other offers that may come along that may be green as green can get and be very desirable? Would the statutory construction allow that, assuming that the board of directors and the customers desired it?
I think
that's the argument I'm hearing. It would.
I think it could, Commissioner, but it's not something that's come to us, and nor have we considered independently anything like that.
All right, fair enough. I appreciate acknowledging, because if this is approved today, we got to be prepared for other products to be similarly available to be added and kind of begin the unraveling of the competitive nature that some people haven't liked from the beginning, to be honest with you. So I think the commission ought to be very careful about this if it does get approved today, because if other products can be offered and you can bundle and maybe add airline tickets or electric vehicle charging rates and bundling packages with SOS, and it all gets conflated to SOS, we could be unraveling retail competition unwittingly. I know that's not the intention here, but and other utilities, and you admitted other utilities may want to avail themselves of this. I do acknowledge that co-ops are treated differently statutorily, but if you go to Maryland's shopping website and there's only one utility on there that can offer various products who's a utility, the others may find it, hey, if SMECO can do it, why can't I do it? And they may find a creative, novel argument to come in and try to get it too. And I think that would be very troublesome for me. Some people have been anchors on retail competition thriving and flourishing in this state, to be honest with you. And I think that's very unfortunate, because I know the legislature intended it to be a benefit to consumers. And the only reason consumers have benefited is because of low energy costs, not because of retail competitive forces. So I just want the commission to have eyes wide open on this. I may have some other questions in a few minutes, Mr. Chairman. Thank you.
Thank you. Additional commissioners with questions?
Mr. Chairman, I have a few questions.
Commissioner Linton.
Thank you, Mr. Chairman, and good morning, everyone. So I guess I keep thinking about Juliet, in the play, what's in the name. I keep feeling like there's a lot of challenge in understanding what this proposal does in practice, in large part because of the name. Historically, when the commission has considered looking at deregulated markets and the product that's supposed to serve as the standard offer service product, it was basically the Schedule R that the utilities offer. So it was whatever that was considered the default type service. There's a lot of orders that the commission has issued over the last 20 years or so that discuss this topic in different ways and under different contexts. So I guess for SMECO, let me try a hypothetical to see if I could kind of tease out some of the concerns that I have. Let's just say that I finally recognize that Commissioner O'Donnell wasn't born with that cheery disposition, but it's the result of living in the Southern Maryland Electric Cooperative Service Territory. So I decided to pack up my family and house and move to SMECO service territory. I call up the utility, I ask for service, but I'm not interested in the deregulated market at this point. I just want the basic service. You're going to offer me SOS. Which one am I going to get?
You would get the SOS without the rider SOSG.
And so how would you let me know that the SOSG even exists?
I presume that the customer service representative would either let you know when you called that this was an option, or in the packet that SMECO sends all of its customers when they move into the service territory, there would be information there that's saying that you've got standard offer service from SMECO. This rider is available if you would elect to, and this is the price, if you decide that you want to avail yourself of that. And then the customer would take the initiative of calling the cooperative and subscribing to that rider as well.
So is this intended to be a different schedule, like Schedule R-G or something, or are you looking at it as sitting as a subset of Schedule R? Or
well, Commissioner, it's not a separate rate schedule,
right?
But like many of I guess all of the riders that the cooperative has, and I think all the riders that the investor-owned utilities have, it is, I'll call it a subset of the rate schedule. Riders are available or applicable to rate schedules depending on customer and the service that's provided. So this would be simply an option to the rate schedule that's on file.
And so as part of your educating me as I'm talking to one of your representatives about service, would there also be a similar kind of education around all of the riders that SMECO offers for that particular schedule that I'm looking at, or would it only be about SOSG?
Well, if you're looking for residential service, Commissioner, some riders
Right.
are applicable by you just taking service under rate schedule R, the residential rate schedule.
Right.
This would be an option, unlike some of the other riders. So in order for the customer to choose the option or not choose the option, the customer would have to know about that.
Mm-hmm. So just as an example, if would the conversation also discuss your net metering rider?
I don't think it does now, so I don't think it would.
Okay.
I mean, I'm certainly, if a customer calls in and said, I'd like to, I'm going to have solar panels put on my house, then we will talk to that customer about the net metering rider.
Yeah, and I think that's kind of what's causing a lot of some of the challenge here is that this isn't, it's a rider. So we're not talking about creating a new schedule or a new rate class. But the name ties it directly to something that's not only in the statute and part of the deregulated market. So it makes it appear as though it's standing even with your Schedule R, even though it's not, and I guess you can correct me on this if it is, but are you intending that it be a separate and alternative option to your default Schedule R service, but we're not actually calling it a Schedule R default type of service, or are we?
Well, Schedule R is, residential service,
right.
and part of Schedule R, unless the customer selects another supplier, has standard offer service as part of it. And so that is the default. As some people on this call have called it, it's the vanilla product. It is it's the standard offer service that we have always offered. And so that's the default. The default would not be the green alternative that's hoping to get approved today.
So as part of my move to Southern Maryland, if I called up and applied for service, I wouldn't be applying for a Schedule SOSG. I would still be on Schedule R, but there would be the rider added on to it.
You would get Schedule R with the plain vanilla SOS.
Okay.
If you were informed that SOSG existed and you decided that that was something you wanted to avail yourself of, you could contact the company and have that added to your SOS price.
Okay, so I thought I heard earlier that you said that this was because of the interest in some of the member owners of SMECO, that there was an interest in finding ways to have the utility purchase or basically have a stronger fuel mix leaning towards renewables. So if that's the case, so what you're saying is that this is not the intention of the company then to replace your Schedule R service now.
Well, again, Schedule R, Commissioner, is not just standard offer service. Schedule R is the residential rate service that we offer to all of our residential customers.
Right.
Part of Schedule R is SOS. And we are not trying to replace standard offer service the way it is now included in our rate schedule R for residential customers. Most of our customers are very happy with the composite of our standard offer service and the price that we offer. And that is shown by how many customers have gone to other suppliers. We offer a highly competitive product, and it's got a fuel mix that people either accept or like. But there are some customers who would prefer a greener fuel mix. And some customers would like to go totally green. And it's this rider that would allow them to go totally green in their fuel mix if they wanted to.
So
I'm not trying to offer to 168,000 customers just one option, a green option, because they seem to be quite satisfied with the fuel mix and price of what we offer in the existing standard offer service. It's for those customers who would like to go totally green and have their company offer a totally green option under their standard offer service. And that's the purpose of this, to try to satisfy, different desires of membership.
So let me ask you a different question and to tie it back to my initial comment. Would the company have any problems with changing the name of it from SOSG to something that doesn't incorporate the SOS language?
I don't think that we'd have any problem taking SOS out and substituting something else that you felt was more appropriate.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner Herman.
Thank you, Mr. Chairman. First, I'd like to ask Mr. Green a question. Mr. Green, the chairman, whose comments earlier I agree with completely, he said that, your comments say that you can't reconcile this product because it's not cost effective. And he said, and I agree, that it's not the lowest cost, but one that's cost effective. So can you respond to that argument?
Well, our comments are not really focused on whether it's cost effective or not, because that's really, quite frankly, it's not important. I mean, the fact is that our prices are not regulated. Supplier prices are not regulated. And so the pricing of it is really not the issue for us. It's that the fact that they have to meet demand, and they've far exceeded that. We just heard that this is a separate product that customers don't have to take, that the SMECA CSR or customer service rep is going to explain to the customer on the phone, and it's going to be, basically our position, that's marketing. But as far as the cost of it, that I can't say that that's an important factor for us, because whether it's cheaper or more expensive, that's really not relevant to us.
Okay, so that's not your argument. Your argument isn't that it's not cost effective.
Correct.
Okay.
So I would say that staff did have that concern in their comments in their buck sheet, but that is not the purpose of our comments that we filed on Monday.
Okay. So I'd like to ask Mr. Spivak a couple of questions. Mr. Spivak, you'll agree that while COMAR 2040-0201B7 limits, I believe it's market or promote. It's not marketing of anything, it's market or promote, but then following, there's also another COMAR provision that says 2040-0202C utility may provide unbiased information about the availability and terms of SOS. So you'll agree that there's two pieces here with respect to, utility actions with respect to SOS, right?
That's correct, Commissioner.
Okay. So if the commission were to order SMECO to provide the staff with its materials about the SOS, the green SOS, and the staff could review it and say, yes, we agree this is unbiased information that's going to customers. Isn't that true?
That could occur, Commissioner.
Right. Okay. So that concern, we can deal with that concern. That this concern that they're going to promote it can be dealt with by having the staff review it and be able to say, we think that's promotion. No, we're good with that. Right.
Right. Yes. I mean, there's some fine lines that are a little tricky there. For example, in the discussion we just heard from Commissioner Linton, if SMECO were to, on its own hook, without being asked during one of those calls, we were talking about, say, oh, and by the way, there's this green SOS adder that you might want to consider. We would view that, for example, as marketing. And so it's, it puts us all in a difficult position in trying to judge between what is marketing and what is promotion. As you said, it could be done, but it's not such a simple thing to do.
Right. And I fully trust that staff does so many things that are so far from simple that I suspect that they could do this. And, if there is an issue, if staff believes there's an issue, they could bring it to the commission and say, we think this is promotion and not just providing a unbiased view of availability. Right.
Yes. Again, we can probably make distinctions when they need to be made. Okay. But I mean, you're talking about a product that at its base is a competitive product. Remember,
Mr. Spivak, that's the staff view, and I appreciate that that's the staff view. But if the commission were to find otherwise, the staff would be capable of making of accepting the commission's order and then moving forward and saying, yes, this is unbiased, informational, it's available. That's unbiased, informational potentially, and this is promotional. So the staff, if the commission were to decide to move forward with this, the staff would then say, okay, well, the commission has decided to move forward with this. Now we are capable of looking at this information and decide, making raising concerns if we think there are promotional materials.
Yes, Commissioner.
Okay, thank you very much. Thank you, Mr. Chairman. I think the chairman already expressed views that are so similar to mine that I'm not going to repeat them. Thank you.
Thank you, Commissioner Herman. Mr. Green, Mr. Spivak, if you could go on mute. Commissioner Richard.
Thank you, Mr. Chairman. Yeah, I really don't have a lot to add. I think I put my my views on the record a couple of weeks ago. And I believe that co-ops do have a special status. I don't just believe. I think it's pretty well written throughout the law in this case. And I think you get into the whole kind of debate everywhere about co-ops. Yes, retailers have had concerns about co-ops, credit unions, what have you, any type of for-profit business. I think is always concerned about the co-op model, but at the end, the owners owned their co-op, and I think in this case, we're looking at trying to balance two important state policies, our environmental policies, and try to do so in a manner that again continues to support retail choice, and that retail choice is provided in co-op territories. It is noteworthy that a lot of people who own their company, I guess, or own their co-op, don't participate as greatly in areas where there aren't the co-op options, but it is what it is in this case. So, Mr. McDougall, I just wanted to again just reemphasize. I think last week you did put on the record that you did intend, the co-op does intend to select Maryland Tier 1 RECs or qualifying RECs. Is that the case?
That is the case, Commissioner.
Okay, so I think that was important to a lot of your co-op owners who are interested in this particular tariff. And then also, I think, again, trying to look to balance and make sure that your members do know about the retail choice. I think you also had committed that when informing your members, the co-op would also remind them about the retail choice options. Is that correct?
That is correct. Our position has not changed for 2 weeks.
Perfect. Thank you. I just wanted again because those were important to me in my decision to support this tariff. So thank you very much. Those are all the questions I have, Mr. Chairman.
Thank you, Commissioner Richard. Commissioner O'Donnell, do I see your mic open?
Yes, sir. Thank you, Mr. Chairman. I want to ask Mr. McDougall another question. The prohibition in the statute on marketing SOS, why do you think that exists? Why do you think the legislature put that in place?
I'm trying to go back to 1998 when this was enacted, Chairman. Commissioner O'Donnell. I suspect it was because and this is just a knee-jerk reaction now, but I suspect it was because the legislature wanted competition from third-party suppliers, that would be non-utility suppliers, to be able to market their own products and create a consumer demand for what they offer, and without the existing utilities, I guess really jading that up.
I think you're generally right. I think it was an acknowledgement by the legislature that utilities had certain inherent advantages with their customer relationships, and they didn't want you marketing and competing with retail suppliers if retail supply competition was going to flourish and bloom in this state. So I think you're generally right, because utilities do have that relationship, but we haven't even implemented supplier consolidated billing yet. So the utilities control all the bills and the whole 9 yards in the communications relationship, and the marketing provision or prohibition was put in there so that the utilities, with their special relationship, weren't competing in the competitive market against third-party suppliers. I think you're right. Having said that, there are green products available in the SMECO service territory through third-party suppliers. Isn't that right?
That is absolutely right.
And why wouldn't this additional product be competing with those other green products that are already out there? Wouldn't it be couldn't a reasonable mind say, I got these options that are green, now the utility is going to add an option that's green. Why isn't it competing with those other attributes that are in the marketplace out there?
Well, Commissioner, I'd like to step back just a second and speak to standard offer service, the plain vanilla standard offer service initially. I think the very same argument can be made for standard offer service. And just because the utility offers standard offer service doesn't mean that it, at least in some camps, that it's competing with third-party suppliers. Other people would say, yes, it is competing with third-party suppliers because it's not just a backstop. It's a choice that customers can make. So to the extent that the plain vanilla standard offer service is not a competitive product, I don't see where the SOSG be a competitive product either. Maybe they both are, maybe they both aren't. But just because utility offers it as a choice doesn't make it competing with the other products. I mean, Mr. Green's clients can advertise, market, promote, offer incentives. We can't do that. We can provide information and that's it. But so I view this very much the same as the plain vanilla SOS. Just because the utility offers it doesn't make it a quote unquote competitive product. It's out there, but the law provides customers to be able to choose.
Well, I think a reasonable argument could be made that this product is available in the marketplace, in the competitive marketplace, and adding an additional product by its very nature, adding that product above and beyond what you term the vanilla, standard offer service, makes it competitive by its very nature because it adds an attribute that's not necessary to meet the statutory requirement. Green, and you admitted that under the arguments made that there's no prohibition on this in the statute, that other products could be added, like electric vehicle charging bundling with Green Rider and maybe other attributes. And to suggest that they're not competitive products, I can't wrap my head around this. I have come to the conclusion, I was very closely divided on this issue, believe it or not. And coming in today, I wasn't sure how I was going to go, but I was getting closer. Reese's clarification of the demand argument really solidified things for me, because the suggestion that somehow that word meant popular demand was preposterous, and Reese's filing of the 17th helped clarify in my mind what that really meant. But I do not believe necessarily, even as much as I want to, that the statute allows this. I think the statute was crafted in a way that didn't want this. And that's my opinion of the statutory construct, having been there when it was passed, having had to vote on it, and now, based on what I know now. So as much as I may want to give SMECO this option, I don't think it's in the interest of retail choice in the state. I think many in the SMECO service territory have not liked retail competition from the beginning and still don't today. And we see that evidenced in flyers and mailers and other areas. And I think this is another frontal assault on trying to push retail competition out of the service territory. So I'll be voting against the application.
Thank you. Do any additional commissioners wish to speak before I call a motion?
Yes, Mr. Chairman. I just had a quick, wanted to follow up on my earlier questions for Mr. McDougall and for the company. I asked earlier if you would be interested or if you'd be willing to consider a different name for this rider. And Mr. McDougall responded affirmatively to that. I believe that's still the case. It's only been a few minutes, so I'm assuming your position has changed.
Well, Commissioner, I'm winging it here. I just got to tell you. But I personally don't see any problem with taking the SOS or standard offer service. What do I call that? Taking SOS out of the name of the rider and substituting something else.
Okay, and I'll just, for everybody else, I'll briefly give a very quick reason why. Educating consumers about the deregulated market over the years has been a bit of a challenge for everybody, commissioners, suppliers, the utility companies, and even the advocacy organizations. But if you go to our websites today, both to SMECO's website and to the Commission's website, and when I refer to the Commission's website, I'm referring to the new one we just launched. We have actual glossary there that defines standard offer service. SMECO has educational or fact sheets, on its website that specifically calls out supplier standard offer service. And by default, you're basically making it a term of art. And it has been for many years. And just earlier today, we had a party that we postponed on granting them a license to participate in Maryland on a deregulated market because of the potential confusion that could have come from their name and the name of a product or service rather that one of the utility companies offers. And so, I mean, to me, this is calling this SOSG, I think is a is a bit of a problem. It raises a number of challenges and potential areas of potential confusion for consumers about what's what. And we've got, again, this is a language that's already out there. There's printed materials that provide the same educational information, and we've been using that particular term for many years to mean something specific. And I won't bother reading the definitions. They're all online today, so you could find them yourself. But both SMECO and the Commission has specific terminology for SOS. So reading the tea leaves, Mr. Chairman, I would propose, and I think that, I don't know if any other party wants to comment on this, but I propose that the company remove the SOS phrasing from this rider. And I mean, if it's just called green or something, that's fine. I don't know what the new name would be, but I don't think that use of the phrase SOS is productive for purposes of long-term education of consumers.
Commissioner Linton, I see your concern, and I've telegraphed my position early on in this case. I'm looking at tariff sheet number 113 right now, where they do refer to it as rider SOSG. Would your concern be addressed if it's just rider G to the SOS? That modification would only require 1 or 2 edits on the tariff sheet. So it would make clear that this is a rider to members that are currently receiving standard offer service, but would no longer be referred to as rider SOS.
I think that's certainly much better, Mr. Chairman. I think that same point needs to carry through on any of the marketing material, excuse me, I shouldn't say marketing materials, I should say educational materials that the company is developing as part of their effort to educate customers about the rider.
Mr. McDougall, you agree?
Yes, I'm happy to comply with that. We could call it Rider G, and that'd be fine with us. Your Honor.
With all due respect, Commissioner Linton, I appreciate your effort because I think trying to head in the right direction. But I would anticipate a rider EV coming down the pike, and I would anticipate a rider N for nuclear coming down the pike, because nuclear is very popular in Southern Maryland, and I would anticipate a lot of other things being just called riders attached to SOS, and to me that just exacerbates my problem with the whole concept here. So I'm having a problem with it.
Thank you. Any final thoughts from commissioners before I conclude and propose a motion? Hearing none, I do believe we treat our cooperatives in the states differently. And after doing my best to harmonize and construct our prior statutes creating this regime, I see no limitations regarding these products that can be offered by the cooperative, in this case pursuant to 510 CG1. These are competitive products. I believe SOS is a competitive product, and the statute says as much, that customers must, of one number of items, must choose SOS, and if they don't choose it, it's their default. So the statute is quite clear on that point from this commissioner's opinion. Separately, Mr. McDougall recently just stated, I just wrote it down. Let me see where I wrote it down. Mr. McDougall, you stated that, quote unquote, we can provide information and that's it in terms of marketing and other undue preference. The law is quite clear under section 7-505 that the utility cannot give undue or unreasonable preference in favor of the electricity company's own electric supply or other services. I think RISA, in its pleading that was filed most recently on August 17th, did make a fine point on page 7 that SMECO's bill presentation would appear to constitute the marketing or showing a preference to SOS. I clicked on the hyperlink to the SMECO website, and was rather dismayed to see the bill format stating that a customer would be saving this much more on SOS if that customer were not on retail choice. The concern there goes beyond what I see on other utility bills, which is simply a price to compare. When SMECO goes forward and makes that absolute calculation, they are excluding any other value, either perceived or real, that a customer is gaining, whether it be an airline mile or a toaster or sleeping well at night knowing that their home is powered by 100% wind. That is a concern. I don't see making a formal complaint in this case, but in this sole commissioner's viewpoint, if a complaint would be made on that basis alone, based on the evidence that I've seen, that complaint would be granted. So something to be mindful of. As I noted at the outset, I believe there is flexibility to grant the Rider G proposal that SMECO is proposing before the commission today. I think it would be important for this commission to see whether or not this program, this proposal, is actually being used. I think it would be instructive to our retail supply participants as well. And in the motion, I am going to condition a compliance filing be filed in 18 months, demonstrating the number of customers and any other details with respect to this program, if this motion has the votes to support. That being said, I move that we approve SMECO's tariff proposals as reflected on revised tariff sheet number 113 to become effective August 19th, 2020, subject to the discussion that was held at this meeting, particularly with respect to Commissioner Linton's proposal to remove SOS from the name of the rider. I move that we require SMECO to provide commission staff with its informational materials 30 days in advance of sending or using the materials to ensure that the information and statements are not deemed promotional. And finally, I move that we require SMECO to provide a compliance filing in the form of a report to the commission on the status of Rider G 18 months from today. The vote begins with Commissioner Richard.
Okay, I think I still support this with all those extra motion riders, but I wish I had had a chance to know these were coming beforehand. But I do support what SMECO is doing, and I vote yes.
Commissioner O'Donnell.
Mr. Chairman, I'm going to vote no, and I'd like to explain my vote briefly. I may want to do this in my heart of hearts, but in my interpretation of the law, and people can have different interpretations of the law, and I'm no lawyer, but I certainly wrote the law for a couple decades. That gives me a little knowledge of the process and what the law means. And I believe the law doesn't allow this, and it doesn't meet the spirit of what was intended in retail competition. And I believe that retail competition has not flourished in the service territory for a lot of reasons. And this is going to be one more where it's going to be a reason to be a deterrent to provide deterrent forces to retail competition and not encourage it. And for all those reasons, I vote no.
Commissioner Linton.
Aye.
Commissioner Herman.
Aye.
I too vote aye. By a vote of 4-1, the motion carries. Seeing no additional business on today's agenda, this meeting is adjourned.
Mr. Chairman.